The Equal Rights Amendment: Past, Present, and Future. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. In 1923, Alice Paul and Crystal Eastman wrote and presented the first version of the Equal Rights Amendment at the 75th anniversary of the Seneca Falls Convention. In December 1923, the resolution was first introduced in Congress by Senator Charles Curtis and Representative Daniel R. Anthony Jr. Between 1923 and 1972, the ERA was introduced in every congressional session, during which time the text was changed to the language passed by Congress. Support for the amendment slowly grew, and the ERA was added to the Republican Party platform in 1940 and the Democratic Party platform in 1944. Inspired by the civil rights movement of the 60s, the women's movement gained power in the United States. And fueled by a speech given by Shirley Chisholm during her first time elected to Congress in 1969, the ERA garnered increasing support. Despite strong support, the resolution was being held in the House Judiciary Committee by then-Chair Emanuel Zeller. Representative Martha Griffiths moved forward with a discharge petition to bring the ERA directly to the floor, where it successfully passed on August 10, 1970. The Senate did not pass the resolution before the end of the session. In 1971, Representative Martha Griffiths reintroduced the ERA in Congress. The resolution was approved by the House on October 12, 1971, and by the Senate on March 22, 1972. The amendment was sent for ratification by 3/4 of the states as required by Article 5 of the U.S. Constitution. States initially rushed to ratify the ERA, and 22 states ratified the amendment within the first year. Progress slowed over the years. By 1977, only 35 of the 38 states needed had ratified. 5 states attempted to rescind the ratification, but scholars and experts agree that this is not legally possible. In 1978, Congress introduced legislation to extend the time limit for ratification. It passed by simple majority in each house. President Carter signed a joint resolution extending the ratification time limit to June 30, 1982. No additional state legislatures ratified the ERA beyond the extension of the time limit. Ratification efforts after the 1982 time limit. Since 1982, the ERA has been reintroduced in every session of Congress. State advocates in the 15 unratified states continue to press to ratify the 1972 ERA in their states. In the 2020s, thanks to the fourth-wave feminism and the Me Too movement, interest in adopting the ERA was revived. This strengthened the three-state strategy, where feminist movement organizations worked in unratified states to reach their goal of the required 38 states despite the time limit being passed. In 2017, led by Senator Pat Spearman, Nevada became the first state to ratify the ERA after the time limit. Illinois followed in 2018, thanks to Senator Kimberly Lightford, Representative Letessa Wallace, and Representative Juliana Stratton. And in 2020, thanks to Senators Jennifer McClellan, Mamie Locke, and State Delegate Jennifer Carroll Foyd, Virginia ratified the ERA, bringing the number of state ratifications to 38. On the 100th anniversary of International Women's Day, Representative Tammy Baldwin introduced new legislation to remove the congressionally imposed time limit for ratification of the ERA. The resolution was introduced in the Senate by Senator Ben Cardin on March 22, 2012. Joint resolutions have been introduced in every congressional session since then, recently under the leadership of Representative Jackie Speier as the lead sponsor in the House, and bipartisan co-lead sponsors Senator Ben Cardin and Lisa Murkowski. The House of Representatives has successfully voted 2 years in a row to remove the time limit on the ERA in its introductory clause. The Senate failed to take up the resolution in 2020 and is currently looking to build upon its bipartisan support for passage of the amendment. Legal challenges and litigation. The Office of Legal Counsel in the Trump Department of Justice under Attorney General Bill Barr issued a memo in anticipation of Virginia's ratification as the 38th state. This memo stated that it was the opinion of the OLC that the National Archivist did not have the responsibility of certifying the amendment since the time limit added in the introduction to the bill and then extended had already passed. On January 30, 2020, the Attorney Generals of Virginia, Illinois, and Nevada filed a lawsuit to require the Archivist to carry out its statutory duty of recognizing the complete and final adoption of the ERA as the 28th Amendment to the Constitution. On October 21, 2021, for the 50th anniversary of the House passage of the ERA, the House Committee on Oversight under Chairwoman Carolyn Maloney hosted a hearing to explore the current status of the amendment and to examine the final steps necessary to certify and publish it as the 28th Amendment to the Constitution. Many lawsuits are in various phases of litigation on behalf of and against the certification of the ERA, allowing for different potential venues for finally adopting it as the 28th Amendment. The ERA Coalition and partner organizations continue to work on strategies and campaigns that will finally secure the inclusion of the ERA in our founding document.